Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back into the Outlaw Lawyers. Josh Whitaker and Joe Hamer, managing partners, Whitaker and Hamer Law Firm, are your hosts. Office is located conveniently in Raleigh, Garner, Clayton, Goldsboro, Fuquay Varina, Gastonia, and Morehead City. They are practicing attorneys here in North Carolina, again, managing partners of the firm. I'm Morgan Patrick, consumer advocate, and each and every week it is always about legalese. But today we're getting into listener questions, and again, we'll have some fun with it. But first up, Josh, is non-compete.
Yeah, we talk to clients a lot, right? This is a call we get a lot. They have signed a non-compete, right? So when they were hired as an employee, when they were hired as a independent contractor, part of their agreement included a non-compete, right? So a clause where basically if you leave the company, sometimes if you're terminated for cause, you can't do the same type of job in a certain area for a certain length of time, right? You can't compete with your current employer. If you were to leave, that's what a non-compete is. And Joe, I guess to get us into this discussion, we're going to have to kind of delineate what the difference is between an employee and an independent contractor.
Yeah, that's a good distinction, and it's an important distinction as well in terms of like you said, who can you even have enter into a non-compete with you? And so there's a few things we look at. There's a few common law things that we look at when we're determining whether somebody's an employee or an independent contractor. There's a behavioral aspect where it's basically, does the company control, or does the company have the right to control what the worker does and how he does his or her job? That's going to speak to whether they're a contractor or an employee, because again, you're gonna see more control exerted in the employee situation than you are the independent contractor situation. There's a financial aspect, or the business aspects of the worker's jobs, of whatever the worker does. Is that controlled by the payer? So things like how they're paid, whether their expenses are reimbursed, who gives them their tools, supplies, et cetera. And then whatever the type of relationship is. So do you have a written contract that establishes employee type benefits? Does the relationship continue, and is the work performed a key aspect of the business continuing? There's a few different factors that we look into there.
And so a non-compete can be signed by either an employee or an independent contractor. So you can, when you start working for somebody, you're usually excited, right? You usually want that job. And you've worked for it, you interviewed for it, and they sit you down, you sign a bunch of paperwork, and at that initial meeting, sometimes you'll get a non-compete in front of you, a non-competition agreement. And so just read it, right? If you want the job, it's something that comes with the job, but you need to know that if you leave or you're terminated in a certain fashion, that they can restrict your employment opportunities down the line. North Carolina has routinely, so the courts generally disfavor these. The courts like competition. They disfavor.
They don't like them. They don't like the non-competes.
Right. But as long as it meets certain criteria, they will enforce them, even though they don't really want to, right? So we talk about time limits and geographic limits, right? So certain professions, you can't even ask someone to sign a non-compete, right? So a lot of professions where you need a professional license, like doctors, lawyers, psychologists. There's a lot of professions like that where it's just illegal. You can't sign a non-compete. It will not be enforced.
The reason being, you've got this license. You've worked hard for this license. It's your sole source of livelihood, and to say that you can't even practice your profession, I mean, you're basically taking away someone's ability to make a living.
And two, they think society needs that professional, right? They think society. The theory is like, hey, we need more lawyers. Not everybody might agree with this, but the theory is you need your doctors out there. You don't want a doctor not to be able to practice in North Carolina because he signed a non-compete and he's got to go to another state and practice. You want that doctor here. So it's professions like that, but pretty much everything else is fair game for a non-compete. And a lot of times this comes up in like a salesman type arena, right? You go work for a company and they give you a customer list to work. They give you some tools, so you know how they operate, they know what they use, and they don't want you to leave and then use that information against them. And so that's where these non-competes come in. North Carolina has they've approved non-competes with time constraints as long as 3 years, and geographic constraints are kind of all over the map. But it depends on your business. But they've had them where they're limited to the whole state of North Carolina. And so these are pretty powerful tools when you find you're not working for that company anymore. You want to keep doing the same thing you've been doing, but they don't want you going to a competitor, and they've got you on a non-compete. So these things come up a lot.
Yeah, they do. And like you said, there's the courts disfavor these, but at the same time, you can, as a business owner, especially in certain types of businesses, you can see the necessity for this, right? Like there's certain businesses that have trade secrets, that have, proprietary knowledge that you don't want someone to be able to come in and then immediately take to a competitor and use against you. You don't want someone to be able to come in and just poach clients. So it's not to say that even though the courts disfavor this, that there's not a legitimate reason for a non-compete. And that's why we say that the courts may disfavor it, but they are allowed, as long as these certain elements are met and taken care of.
And the court will look at it too. It can't be punishment. It has to protect a real interest. A company can't enforce a non-compete against you just because they don't want you to be able to make a living. It has to protect their real interest. So that's the way a lot of these get attacked. And then figuring out what damages are. If you have a non-compete and you break it, you start working for a competitor, your old company will sue you to get a restraining order to restrain you from taking that job. And then they have to continue on and prove, what their damages are. And so sometimes the damages will be written in there because it's hard to prove, right? It's hard to prove what your damages are when someone leaves your company.
And we call that the old liquidated damages clause, where you just when damages are difficult to ascertain, that's our fancy way of speaking it. You just put in the liquidated damages clause, which is basically, hey, we're mutually agreeing that this amount of money is what we're going to state will make this better in the event it goes south.
And the time when you sign your non-compete is important too. If you sign it at the beginning of your employment, whether you're an employee or whether you're taking work as an independent contractor, if you sign it at the beginning, that's when you should sign it. You should sign it at the beginning. If they just bring it to you one day, you've been working for like 9 months, they just give you something new to sign, don't give you a raise, don't give you anything new, then that non-compete's probably not very valid. So, an attorney is going to ask you, well, when were you presented this? Did you have time to review it? Did you have time to take it to an attorney? When did you sign it? And so all that becomes important when you analyze it. And that's what you should do. You should always talk to an attorney about your non-compete. If you know you have a non-compete, you have a copy of it, before you quit your job to take a job that may be in violations, you should talk to an attorney, right? You should get a professional to evaluate that and the likelihood that it could be enforced. And then you need to understand too, even if that attorney says, hey, I don't think this will be enforceable, that doesn't mean that the company can't still try to enforce it.
And we've done that too. We've talked to clients who've come to us and presented non-competes, and we'll say, there's some of these things that are a close call, right? Because you're talking about standards of reasonableness, and you can look at what the court's done in the past, but you still got to let clients know, hey, there's a risk, right? There's a risk attendant in you presenting this to a judge or getting in front of somebody who may make a different determination. So sometimes in those scenarios, we'll tell folks, hey, this isn't a great non-compete. It's close. You may want to look at trying to negotiate some kind of amicable settlement, whether it be stroking a check to somebody to make it go away. There's situations where you're still not going to want to roll the dice, even if, we've got a feeling that it may not be enforceable.
Yeah, you can definitely negotiate that as part of your severance, right? If you're in one of those jobs that would normally give you a severance package, you can give some of that back in exchange for them waiving the non-compete or making it shorter or having some sort of signed agreement that changes that a little bit. But the big thing is on the front end, especially if this is like an industry you've been in your whole life, you're like 20, 30 years into your career, you're about to go to a new company and they want you to sign a non-compete. You might have to think about that, because if you're there for a year and it's terrible and you want to leave and you sign a non-compete and this is what you've done your whole life, this is how you feed your family, a non-compete can really cramp your style. So it's something I don't think people think about it a lot. I'm sure we've got older clients who've had to confront it a time or two, but especially if you're on the younger side, you're just getting into an industry, you might not think about it as much. But
let me ask you guys a question. I mean, do you guys see a lot of this? I mean, do you sit down with, say, the company, or do you sit down with the individual where you actually are talking about non-competes that are in a contract?
I'd say both. I mean, we see it both ways. I mean, it's not overwhelmingly prevalent. It's something we see on occasion. We do a lot of things, so we're not strictly focused on that business aspect, but we do have, business clients, obviously. So I know personally I've had both ways where we've put together non-competes for folks and made sure we're checking those boxes on reasonableness to make sure that it's as ironclad as possible. And then we've also looked at them for folks and tried to advise on how to, whether they were sufficient and how to get out of them.
Yeah, I spend a lot of time. I have several clients who are businesses that operate, of course, nationwide, and then do things in Europe, do things in Canada. And non-compete is something that they're very much worried about because they're fighting with other businesses that are kind of in the same industry. And once you get far enough along in your industry, there's really only 2 or 3 players that are all kind of fighting for the same clients. And that's when non-competes really get serious, kind of kick up a notch, but they're negotiated. They're negotiated when you take the job, and you can still negotiate it on your way out. But it's just something to be aware of. I've definitely met with people who had no idea they signed one until they quit. And then their boss was like, well, you can't take this next job because of this. And then they come see me and they're in a bond. So just being aware of it as a thing that exists, so you don't just sign it without thinking about it.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm, where you can find them managing partners there. Offices conveniently located: Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, Gastonia, and in Morehead City. They're practicing attorneys here in North Carolina. So we're going over listener questions. Non-compete is down. And next, attractive nuisance. We'll explain coming up on the other side. Now, listen, if you have a legal situation that you are facing and you've got questions, you need some answers, you can always call Whitaker and Hamer. Here's the number: 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what that call is about, and an attorney with Whitaker and Hamer will be in touch. And you can always email the show. Send your questions to us. We'll answer them on a future broadcast. Questions@theoutlawlawyer.com. We're back right after this.